Can state governments use social distancing directives to ban you from protesting social distancing directives? Well, it seems like they certainly think they can. The Raleigh Police Department said that protesting is non-essential activity, and it's appropriate in 2020. They said it on Twitter. You know, the Raleigh police talked about how they were asking people to leave because they were in violation of the North Carolina governor's executive order. Someone asked what part of the governor's order was violated here, and the police said protesting is a non-essential activity. Apparently, there's a lot of people who like restricting First Amendment rights. Indeed, Governor Gretchen Whitmer is talking about the fact that just because there was a protest at her state capitol in Lansing, that the government was going to have to extend the social distancing lockdown.
People came and converged together in Lansing, and then they went out back to their homes across the state of Michigan. The odds are very high that they're spreading COVID-19 along with it. And so it's that kind of irresponsible action that puts us in this situation where we might have to actually think about extending stay-home orders, which is supposedly what they were protesting.
Now, while Governor Whitmer seems very, very eager to be restricting her citizens' First Amendment rights, there is this just underlying question about whether or not this is constitutional. Because while in normal times it seems obvious that the government couldn't just flat out ban people from protesting, with a public health emergency, the question seems a little muddier and a little more unclear. So we'll explore whether or not, in fact, Governor Whitmer can indeed use social distancing measures to ban you from protesting. Social distancing. But first, Human Events has a YouTube channel. Subscribe to it, please. It helps us. Thanks. Back to the matter at hand, the Raleigh Police Department saying that protesting is a non-essential activity. Well, you might start with analyzing any question. Obviously, this is a First Amendment case about your First Amendment right to assembly. And these are what's called a content-neutral restriction on speech. So a content-neutral means that you're not discriminating on the basis of what's being said. You're just discriminating against the type of against speech. Period. So, normally content-neutral restrictions are things like imposing limits on the noise level of speech, capping the number of protesters who might occupy a given forum, barring early morning or late evening demonstrations, that sort of things. And government, state, local, federal can put in place restrictions on speech that are content-neutral. But there are limitations on that. They have to generally survive a three-pronged test. The regulation must be content neutral. You can't be discriminating against what they're saying, but merely the time, place, and manner that they're saying it. It must be narrowly tailored, the restriction, to serve a significant governmental interest. I think it must be compelling. I think that's the right language. I got this wrong here. And it must leave open ample alternative channels for communicating the speaker's message. So that's the general framework for thinking about First Amendment rights. But it's important to realize that this isn't normal, so maybe the normal framework doesn't apply. And because it's a public health emergency, there's a little more leeway for government officials. So there's a case, Jacobson versus Massachusetts. This case was ruling on the constitutionality of mandatory vaccination laws back in Massachusetts, all the way back in 1905. But it contains very important language and reasoning that courts are now using to understand what exactly is their role and how much flexibility do the other branches have in dealing with a public health crisis. So this is a very recent opinion, April 7th, 2020, in the Fifth Circuit Court of Appeals that covers Texas. It's a big court opinion. And in this opinion, in the case In re Abbott, the Fifth Circuit said it was acceptable for the state of Texas to ban certain abortion procedures as a public health measure in the short term to preserve resources to deal with coronavirus. And in this case, they relied on Jacobson to kind of understand how far exactly can state and federal governments go when dealing with a public health emergency in terms of infringing on your rights. And they started with this particular reasoning right here. And this is a quote from the case to this is the rationale about why states can go further. Quote, "In every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand." It also explained that, quote, "The liberty secured by the Constitution does not import an absolute right in each person to be, at all times and in all circumstances, wholly freed from restraint." So the logic here is, in public health emergencies, sometimes your rights get curtailed, and that's the way it works in, quote, every well-ordered society. It's not unreasonable. Also in Jacobson, the court laid out a way of thinking about when it is that courts can still intervene against something that is still unconstitutional, even though it's a public health emergency. And they say, quote, if a statute purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects, or is beyond all question a plain and palpable invasion of rights secured by the fundamental law, then a court can strike it down. The court describes this as being a test of whether power was exercised in an arbitrary and unreasonable manner. So there are examples of that happening where it looks like a court would find that it was such a plain invasion of rights that there would be, they would strike down something the city was doing. For example, you might have caught that their mayor of Greenville, Mississippi was banning drive-in church services. We did a whole video on that a few days ago. That is pretty questionable, even in the middle of a public health emergency. And there's probably a reason. Just recently, the Greenville mayor said they were ending their ban on these services after the DOJ intervened. The DOJ didn't actually physically go down there, but they filed what's called a statement of interest in support of the plaintiffs who were suing the city of Greenville. In this statement of interest, they talked about how Jacobson and Abbott get the basic framework right, but that there is still this room to figure out if the government has gone too far. So quoting from the DOJ's statement of interest, the court must be appropriately deferential to the expertise of public health officials in evaluating potential distinctions between a drive-in church and other permitted essential activities where people gather in cars. But such deference will not justify action that is, quote, beyond all question, a plain and palpable violation of free exercise principles. So if the court determines that the city's prohibition is not the result of a neutral and generally applicable law or rule, that's in the religion content, so it's a little different than free speech, the court can sustain it only if the city establishes that is the least restrictive means of achieving a compelling governmental interest. That's also a different standard, religion. But anyway, the basic concept being that the way that DOJ thinks about it, because it's a public health emergency, Jacobson said you need to have a super, super clear violation of rights. So in order to say that what a state government's doing is unlawful, as long as there's a clear relation between what they're doing and public health. So let's think about that in the context of free speech. So the general framework, again, going back, remember, regulation's got to be content neutral, narrowly tailored to serve a compelling governmental interest, and it needs to leave open channels for communicating the speaker's message. So this may not be the only framework. Essentially, you're layering this on top of Jacobson, which says be really deferential to the government in a public health emergency. So basically, the way I think that a federal court would handle it, given these different opinions, is they would say, we need to find something that isn't even close, right? That is a very, very obvious, overly, restriction on free speech that's totally unfair. That's not even close to narrowly tailored, that does not serve a significant interest. And that's the kind of speech restriction that will come down. And under that framework, I don't think that essentially the restrictions on protests, I don't think those would be found unconstitutional. I think that under current law, as ridiculous as it sounds, I think state governors would have the ability to essentially demand that people break up a rally or a gathering that's not adhering to social distancing guidelines, even though that gathering is targeted at the very policies that are being used against them. So, and why do I think that? Well, there's a case that came out of the New Hampshire state courts, the New Hampshire Supreme Court, actually. Or sorry, not the Supreme Court, the Superior Court in the state of New Hampshire, but it's a state court. It's not federal court, so it doesn't bind the federal government, but it's important. So this is a case where some people sued to get an injunction and stop the state of New Hampshire from enforcing its shelter-in-place order that included a ban on gatherings of more than 50 and various things of that nature. And the judge in that case first found that, based on some cases I don't think are that persuasive, that basically that the government can just do what it wants in an emergency or has a lot of flexibility. And I think they should have used Jacobson. They didn't, but whatever, we're going to skip past that. The key thing to use from this case is the fact that in addition to doing the analysis of the emergency, they also just did an analysis of, whether or not this order from the governor would pass muster under normal First Amendment rules. So again, this is what the court's saying. Although the court finds that the governor may suspend or limit constitutional rights during a state of emergency, the court will also analyze the facial constitutionality of the relevant executive order. And basically, New Hampshire has a First Amendment very much like we do. And it's, as it says, in interpreting that, the court relies on federal cases interpreting the First Amendment to the federal Constitution. So, and it's like, again, so it's similar. Like, basically what this New Hampshire judge is doing is analyzing this rule the same way a federal judge would analyze a First Amendment claim, and whether or not there's an unfair time, place, and manner restriction. And so, again, here's what the court tried to figure out. Is the regulation content neutral? Does it narrowly serve a significant governmental interest? Does it allow for other opportunities for expression? That's very similar to what the rules are under Ward v. Rock against racism. And so the court went through this all analysis. It looked at the fact that the restrictions are content neutral. They ban all gatherings of 50 or more people. Just because they include the word spiritual, they detail, there's a whole slew of events that they apply to. This is not about what type of speech you're engaged in. It's about the fact that we don't want, the New Hampshire state did not want people getting together in groups of 50 or more. That means it's content neutral. It's not targeting the specifics of what you're saying. Second step, is it narrowly tailored to serve a significant government interest? The New Hampshire court says, stopping a pandemic is a significant government interest. And if the regulation is adhering to CDC guidelines, then that seems pretty narrowly tailored to us. Whether or not that would actually hold up in a federal court, whether or not that somebody would follow that reasoning is unclear. But again, remember, because it's a public health emergency, they're going to be really deferential. And so if it's a close question about whether or not these shelter-in-place orders are narrowly tailored, it's going to be really challenging. And then finally, do people have an alternative way to speak? The final analysis, and the analysis here makes sense to me. The idea that we're not saying you can't express your opinion, we're not saying you can't protest these things, but you can't do it in ways that violate the social distancing protocols. Meaning, you need to spread out, you need to be safe, and you can speak online, you can speak however you want. You just can't speak at a tight gathering of 50 people for public health reasons. So, what this shows is the New Hampshire Supreme Court concluded, like, these sorts of, it wasn't specific to the protests, but it was that the gathering bans themselves and the banning of these sort of peaceful assemblies, that they're completely lawful, and they would be lawful even under normal First Amendment law, which is really something. So, they don't even need the additional protection of this Jacobson case from 1905 that gives even more deference to the state and local officials to be pass muster constitutionally. So that suggests that it would be really, really hard to challenge these rules, even though it's a state governor using social distancing rules to ban protests against social distancing. Let's take a step back. Like that's just the law. Like, let's talk about what should state governors be doing. Remember that, yesterday we did a video on Facebook banning lockdown protests and banning the organizers. It's really not a good thing. And the American Conservative had a good piece from Matt Purple talking about how we've broken the public patience curve and how, people are going to get tired of lockdowns and, governors shouldn't overstep. People like Fuller Sunbridge, Gretchen Whitmer, shouldn't be overstepping, should be a little more understanding of other people. I think it's generally a very bad idea to ban protests on using the rules that are being protested. I think that's probably not something that's just going to make everybody lose their patience with the lockdown, as they say. And we, at Human Events, we very much believe that the social distancing measures were necessary, and that governments needed to step in and do things to protect public health. But I don't want to see stuff like where protesters are getting arrested. I think that's bad. So even though I think ultimately they have the legal authority to break up these protests on the grounds that we have a content neutral regulation saying you can't gather in big groups because that's how disease spreads. And that includes you protesting against those very rules. Even though I think that's probably lawful, I think that governors should do everything in their power to avoid arresting people over that stuff just because it looks terrible. So that's all I got for you right now. Thanks for watching. Hope you enjoyed this. Hope you got value. If you did, remember, hit that subscribe button, Human Events, the YouTube channel. We're going to be here. We're going to keep giving you rigorous, detailed analysis of what's going on in the news and be a deeper understanding of the legal authority and whether or not people's claims make sense. So if you like that, hit subscribe. That really does help us out and helps us spread our message. Thank you so much. Hope you enjoyed it, and I will talk to you tomorrow.